Good morning, everyone. Thank you for joining us on this very sunny Tuesday morning. I've been told that we've got a high number of attendances and it hasn't dropped because of the sunny weather, so that's fantastic. Thank you. Obviously, we're here to discuss the recent Supreme Court decision of Iconix and Dream Pairs. I'm Stephen Lowry and I head up the trademark practice here at Brandsmiths, and I'm joined by my colleague Andy Lee, who heads up the IP litigation practice. For those of you who don't know, Andy is somewhat of a trailblazer in the UK trademark industry. He has had his hand, he paid me to say that, he's had his hand in many recent trademark cases and changes in our law and practice. I'm sure he'll have his hand in many more in years to come. But for today's purposes, we're going to discuss Iconix and Dream Pairs. Before I hand over to Andy to discuss the facts of the case, we have a little bit of a loose structure. We'll talk about the similarity of the mark against the sign. We'll talk about the concept of post-sale confusion. We'll also go on to appeals more generally, the purpose of appeals, when there should be appeals. And then we will talk about the practical application of this decision in an infringement context, but also from a sort of registry tribunal context as well. So without any further delay, pass on to Andy.
Welcome, everyone. Thank you, Stephen, for those kind words. I didn't actually pay you to say them, but thank you very much. So just a quick background as to what the case was about, and I think we'll just flash up, if we can, the mark and the sign and how it was actually used in practice. So the centre of this was the Umbro brand, but more specifically their very famous double diamond logo, which you can see on the left there. And the allegedly infringing sign in question was the Dream Pairs logo, which you'll see on the right there. And that's how it sort of appeared on the register as well. And then just if we can just flip on quickly, that was how the Dream Pairs logo appeared on the Dream Pairs football boots. It was essentially sort of square on its side on one of the points. So Iconix brought infringement proceedings in the High Court, relying on two bases essentially: Section 10.2, which is a similarity of sign and mark with similarity identity of goods where there exists a likelihood of confusion, and it also brought on the basis of Section 10.3, which is a mark with a repute, and then there's various bases in that: dilution, tarnishment, unfair advantage, all the rest of it. The case went to trial before Mr. Justice Miles, and he found that whilst the Umbro marks had essentially a very high distinctive character inherently and through use and a significant reputation, there was no likelihood of confusion. He essentially rejected the Section 10.3 case on different bases. Well, there was a couple of strands to that, but in essence, that case largely stood or fell with 10.2. He said that, in his view, there was a very low similarity between the mark and sign, and he said that applied at both point of sale, which was the listings on the eBay and I think Amazon website, and then also in a post-sale environment. And obviously the post-sale environment is one of the big issues in this case. That went to the Court of Appeal, where the appeal court, which comprised of Lord Justice Arnold, Lord Justice Burse, I think Lady Justice King from memory. So obviously there you've got the two probably leading IP judges in the court system, Lord Kitchen having, I think he might have retired by then or was about to, from the Supreme Court. And they upheld the appeal. And the basis on which the Court of Appeal really focused was that the judge hadn't properly considered the post-sale environment, in particular, the realistic and representative viewpoint of looking down on someone's shoe or boot, and they said that would make the sign more similar to the trademark. The Court of Appeal, where it was actually an unusually short judgment from the Court of Appeal, particularly Lord Justice Arnold, and I think it needs to be remembered that post-sale confusion in this jurisdiction, even though there's a lot of cases, some of them going back centuries, which sort of recognise the principle in in sort of terms. It was really Lord Justice Arnold who started to build this up in this jurisdiction and was really keen on it. Dream pairs then appealed to the Supreme Court and were given permission to appeal. Now, the three bases on which dream pairs appealed to the Supreme Court were essentially to consider, one, what is the correct way in which you compare a mark and a sign? Because in the Section 10.2 context, and that was what the appeal was really about, it was accepted that 10.3 stood or fell with 10.2 purely on the basis that if there was a likelihood of confusion, even though you don't need confusion for Section 10.3, a likelihood confusion would also lead to dilution of the mark. So one of the three sort of heads of damage. So that was accepted, but it didn't really play any part in the Supreme Court at all. So the first basis was, well, what is the correct way of comparing a mark and a sign? Because for Section 10.2, there first has to be some similarity between mark and sign before you then get onto the likelihood of confusion test. There also needs to be some similarity between the goods, but it was accepted in this case they were identical. So if there'd been no similarity between the mark or the sign, you don't then get into the likelihood of confusion. The second basis was, well, should post-sale confusion really be a thing in UK law? And in particular, should it be actionable without actually showing that it would impact a subsequent transaction? So in other words, if someone's confused in the wild, is that sufficient, or does it then need to be shown that it would likely impact a subsequent purchasing transaction or point of sale? And then the third ground, which in some ways was possibly thrown in as a bit of I wouldn't say a make weight, because it's obviously very important in this case, but it was thrown in that the Court of Appeal should not have interfered, that even if, minds can differ on whether two marks are confusingly similar, the judge had applied the correct law and he didn't think they were, and the Court of Appeal, even if they strongly felt that there was a likelihood of confusion, shouldn't have interfered. So that's the sort of background to the case. The case was heard in, I should know this, February or March this year, before 5 judges in the Supreme Court. Lady Rose, I'm going to struggle to remember the names here, Lord Briggs, Hamblin, Stevens. Anyway, so there was a panel of 5 judges. Interesting, none of which were IP specialists at the bar, albeit some of them had done a decent amount of IP in their practice. So Lord Briggs had done a couple of cases, Lady Rose had done a few, I think she did ASOS and a couple of others. So they obviously had experience, but actually in the Supreme Court, given the sort of specialism of the judges and the different type of cases they hear, they're Supreme Court judges for a reason. They're obviously sort of top of the tree in their intellect and hear all types of cases. So the judgment was handed down, and as people now, on the 2 key points of law, the court dismissed the appeal. But they allowed the appeal on the third one, which I said at the start may have seemed like a bit of a make-weight ground in a way, but actually seemed to get a bit more traction as the hearing approached, and in the hearing actually it seemed that was something the judges were a little bit concerned about, as to whether the Court of Appeal had just interfered because they didn't like the decision, not that the judge hadn't actually done anything wrong. So Stephen, I think it might be useful. I think what might be helpful is if we discuss each ground individually. Well, actually, I think we'll discuss the first 2 points of law individually and how they impact on practice. And then we can look at the appellate principles. Mm-hmm. So I think on the similarity issue, the key point there was when you're comparing a mark and sign, how do you do that? Do you just look at the mark and sign in the abstract? And if there's some similarity, go on to the next stages? Or can you actually say, well, if you look at these marks intrinsically side by side, they have a certain degree of similarity, but actually if we just call it the allegedly infringing sign, or in a registration context, the sign that's been opposed, if you like, how might that actually look in practice? How might that be used in respect to the goods or services that it's registered for, used for, or applied for? And might that increase the level of similarity between the trademark and the sign? And there was some differing, I think historically, Stephen, it was probably a lot of lawyers thought, well, you just look at the mark and sign intrinsically.
Side by side.
Yeah, and then there was the equivalenza decision from the Court of Justice, which seemed to suggest that's what you did as well. What equivalenza really said was that what you can't do is you can't take a mark and sign and say they're similar, but say that because of the way that the sign will be used, it will be less similar. So you can't rule out intrinsic similarities through a post-sale environment, if you like. But what the Supreme Court did say was it is permissible to, when you're considering that threshold question of whether the mark and sign are similar, to consider how the sign might be used in practice, provided, and this is going to be the words that are going to be in every letter of claim and opposition and skeleton argument, provided what you're considering is a realistic and representative scenario. So in this case, for example, it would have been permissible, or it was permissible, to say, well, if you look at the Umbro double diamond and the Dream Pairs logo on paper, are they that similar? Maybe, maybe not. And in fact, in this case, there was a first an opposition division, I think, from the EU IPO, which held there was no similarity whatsoever. They were completely dissimilar. Mr. Justice Miles said they were faintly similar, but that was enough similarity for him to go on to consider the ultimate question. So going forward, at the stage of comparing whether mark and sign are similar, what you now need to also consider is how the sign, if you like, might be used in practice, and what a realistic and representative scenario would be for an average consumer or consumer encountering that sign. So, Steve, what did you think of that? Because obviously, an infringement perspective, so the other thing to feed in that, of course, is the higher the similarity between the mark and sign, that is a factor which goes into the likelihood of confusion test, and the principle of independency. So, mark which isn't particularly similar to a sign, but for identical goods, that can sometimes be said to offset that. But in terms of registry practice, Stephen, how do you think this finding on comparing mark and sign is going to impact practice?
Yeah, I think it's a really good question, and it's something that it wasn't really specifically addressed in the Supreme Court decision, but obviously you can draw some inferences there. Historically, I think there's been a bit of a strange approach before the tribunal whenever it comes to oppositions and validations. We look at marks side by side, the visuals, the ors, the conceptuals. We move on to the analysis with the goods and services and so on and so forth. But we didn't really consider the post-sale stuff. In fact, we were often told not to consider that we really should focus on side-by-side intrinsic qualities of the respective marks. I find that quite arbitrary and quite bizarre, not least because when you're looking at likelihood of confusion, part of the analysis is, you look at channels of trade, distribution channels, users. So you are considering the mark in the marketplace. And I think you're also factoring in imperfect recollection. Well, whenever you're looking at marks side by side, there is no imperfect recollection. You're looking at them, and so I think people are going to be it has appeared before the tribunal post-sale confusion. I think we're going to see it a lot more, and so we should. I don't think we should have any sort of arbitrary barriers to that. I think what's very important is that trademark lawyers really follow that sort of realistic and representative examples of post-sale confusion. I think it's important that you don't, that old saying, don't destroy the cake with the turd, because if you get carried away and you start throwing in examples that really you're not going to take the hearing officer with you. It could ruin the rest of your arguments as well. But yeah, I think we're going to see a lot more of that stuff. I think it's very important, but not just before the tribunal. I think even before you get there, whenever trademark practitioners are looking at doing clearance searching for use and registration, obviously we have to consider the marks, we have to consider the goods and services. We already consider whether or not third-party marks, prior rights, etc., are vulnerable to attack, whether that be non-use revocation or invalidity. But on top of that now, depending on the sector that we're looking at, where the marks may appear differently in practice, or may be obscured, or maybe looking at them, in a different way. I think you're going to have to factor that in as well, and it's going to make the job for trademark lawyers. Trademark searching has always been a difficult task. Nobody has a crystal ball. You're essentially trying to predict whether a mark will achieve registration, whether it be opposed, and you're also predicting whether or not somebody will take infringement action against you. I think now that sort of layer of complication has just been added to by this case, so thank you, Andy.
My pleasure. Thank you very much.
But it's important. It's important for the practitioners now to be considering how marks may appear in the marketplace, and how consumers may perceive them, and how brands are marketed as well, marketing practices.
Yeah, because it's interesting. You look at this issue of post after sale realistic and representative scenarios. They now factor into whether a mark and sign are similar, the Supreme Court was saying, well, what you can't do is take a realistic and representative scenario and say, well, the mark would look less similar.
Yes.
But what you can do is say it would look more similar.
Yeah. So it's a real win for brand owners.
Yeah.
Yeah. It's an extra weapon in the armory.
Yeah, and I think it is quite clear. A few people had mentioned to me, does this apply in registry proceedings as well? And I think it's quite clear from the Supreme Court judgments that it does. I remember in the hearing, Lord Briggs was very, because I think what we were sort of saying in respect of the equivalenza decision was, well, that's a registry decision. That's all side by side on paper. You do it that way. But Lord Briggs was sort of saying, well, why should there be a difference? Ultimately, it's about, comparison of mark and sign. Why should there be a different practice in the registry as to infringement? Obviously, infringement, when you're looking specifically at the context of use, but actually, why should it be different how you compare a mark and sign? And then I think that what this decision also shows, when we look at this a bit more, is trademark laws really now. I think years ago, before I was even practicing, which wasn't that long ago, but 20 odd years ago, I think, maybe slightly before that, it was very much both for registry and infringement, a mark and sign side by side. So in infringement proceedings, you didn't look at the context of use at all. You just said, well, there's the mark, there's the sign. And then the judge would make their mind up. And then through the EU jurisprudence and L2 and all the rest of it, and then leading into Specsavers with Lord Justice Kitchen, in infringement, it was all about the context of use. And now I think it's gone even further, where what they're saying is, well, you've got this statutory right, this statutory monopoly. And particularly in the registry, I think it's this sort of hypothetical trademark world where it doesn't matter whether the mark's been used, and actually neither mark might have been used.
Exactly.
But what you have to consider is, well, how would these things be used in the real world? And I think that's a recognition from the Supreme Court of the thing we were saying, which they recognise, is that trademarks have a very important existence other than just being trademarks at the point of sale. And actually, for people who are not IP lawyers and have no idea about this case, they use trademarks every day in their life. So they go into a bar and they want a pint or a cocktail or whatever, or maybe cocktails by example, but they want a spirit, and they see what's on offer by the brand names of the products, and they know that if they order a pint of Guinness, they're going to get a certain quality of product. Or if they're walking down the street and they want a coffee and they see a Caffè Nero or they see a Costa, they recognise the brand. So it's And brand owners, and I think Iconix are a good example in this, the Umbro brand has been a brand which has developed over decades, where there's been significant amount of investment in that brand, building it. And so the Supreme Court are really saying, like, that needs to be recognised in the post. It needs to be recognised and protected. Now, on to the second topic. So this was whether there could be, essentially, I mean, it wasn't as simple as stating it in this way, whether post-sale confusion should be a thing at all. It was slightly more nuanced than that. The real point was, well, should it be actionable? Post-sale confusion, should that be actionable merely if someone is confused in the wild, but there's no reason to think that that would impact a subsequent purchasing decision or a point of sale? They wouldn't, or they wouldn't be confused at point of sale, because in this case, if you remember, the judge held that because of all the contextual matter on the Amazon and eBay pages, there would be no likelihood of confusion. And so the argument was, well, should it be good enough for a trademark owner to say, well, that's fine, someone's seen someone play wear these boots on a football pitch, might think they're Umbro boots, but if that wouldn't actually impact a purchasing decision later or point of sale, should that be actionable? And so this was obviously a really interesting bit of the case. And actually, to be fair to Lord Justice Arnold, whilst they did overturn him on appeal, the rest of the judgment, and particularly on this point, is a complete validation of what he's been saying all along. So he's probably not too he'll be happy with that bit. I mean, question whether he, whether he's going to be bothered at all. But and so what the court found here was that it is sufficient when considering a realistic and representative scenario that the average consumer, or a substantial proportion of them, would be confused purely by seeing the accused mark or accused sign in that realistic and representative scenario, even if it wouldn't actually impact a subsequent purchasing decision. The damage to the origin function is complete on that basis. Now, see, there's been a few people who've said and actually a lot of the academic commentary, which was relied on by Dream Pairs, made this point, said, come on, that's taking it a bit too far. Why should trademark owner be able to bring proceedings and get relief simply on that basis? Does it not need to demonstrate more? And I think the Supreme Court I think the reasoning behind the Supreme Court was a number of bases. Firstly, they said this suggestion it has to all the European cases which applied the Arsenal and Reed and Picasso and all the rest, which said post-sale confusion was a thing. None of them said, well, it also has to be shown it would affect a subsequent transaction, number one. I think the second reason is when they talk about the list of prohibited uses, which is non-exhaustive in section 10.4. They say, well, look at all of these, the vast majority of them actually. Well, air sales not actually mentioned, but actually a lot of these acts are preparatory to a sale and they're prohibited. And I think the third reasoning behind that is that how would a trademark owner ever know that, if someone's mind's been abused, until they're disabused, they don't know they've been abused, if that makes sense. So in other words, if you're confused, you don't know you're confused until. And so, for example, as a trademark owner, how would you, imagine a scenario where someone saw a pair of Dream Pairs, ship their boots and thought, and this wasn't actually in the case, for example, just hypothetically, they didn't like the look of them, or someone said, these are falling apart straight away, whatever, and you thought they were Umbro boots. You may never tell anyone that. You may have been thinking of buying a pair of Umbro boots, but now you don't. But why would you go and tell anyone that? You might just say, actually, I'm going to buy some Adidas ones. So I think it's a brand protection point, I think, to say, well, evidentially, it's going to be difficult for a trademark owner to actually gather that evidence of the people saying, well, I wouldn't have now bought a boot, so I didn't go and make the purchase I was thinking of. But I think it's also recognition that the origin function continues to function, on a continuous basis after goods being sold. And I think it does. It obviously does. I mean, again, looking at people who are not IP lawyers, you see people all the time, they see their friend with a new handbag or a new pair of trainers or whatever, and they go, I really like them, and that's that brand. And that's the origin function, if you like. And some of the other functions in there about, investment and all the rest of it, but the main one being the origin function of signifying the trademark owner's goods. So I think that's a really interesting point. And I think from an infringement perspective, what we're going to get in all these cases now, well, I think there's a couple of things to think. In every infringement case, you're going to have probably people saying what these hypothetical, realistic and representative scenarios. And it'll be a question of evidence and submission. And actually, if you look at the Tom Brown case that came out before the Supreme Court hearing, I remember in this case, both sides got very excited by it. And we're thinking it supported them. And I think, but what's clear from that judgment is, from Mrs. Justice Joanne Smith, is she was able to apply the principle of post-sale confusion without any difficulty. But in that case, she rejected what was said to be realistic and representative scenarios. Because from memory, in that case, the Tom Brown stripes are sort of far horizontal, Adidas is 3. And I think Adidas was saying, well, yeah, but imagine if someone sort of was running or sort of bent over or something, and they would then look horizontal. And she just said, well, she didn't think they were realistic and representative, particularly the running example, because when someone's running, it would very quickly be going back to how it was. And so, but I think the other area it might be use for brand owners is, I think in some of the section, if you look at, say, the Thatcher's decision, or you look at the, I think Thatcher's is a good example. That case really succeeded on 10-3. I think the 10-2 case was, obviously the brand names were different, but I think similar to Moroccan Oil, maybe one of the things that was relevant in that case is, people shopping in Aldi, they know they're not getting the real thing. But actually, if you take the Thatcher's case now, would a realistic and representative post-sale environment be, I go in and buy a 4-pack of cider and I take it to a house party and I put it on the side. Someone just glances at it and thinks it's Thatcher's. Or I'm drinking a can and obviously I'm holding my hand, and some of was it Taurus, that name is, that's obscured now. Mm-hmm. Is that a realistic and representative scenario which would
I think that line of defence with the, people know where they're purchasing, they know what Aldi is, they know what Lidl is. That was always a line of defence, and that would sort of erode any confusion argument. But like you say, if these goods are ending up at a house party or elsewhere, then that could increase the similarity and thus the likelihood of confusion.
I mean, the other thing I was thinking of as well, which is interesting in infringement perspective, is, and I don't think this was ran in this case, but how will it affect injunctions? Because arguably in this case, if the appeal, let's just say the appeal had been upheld, it would have been on the basis that the judge hadn't really considered the looking down maybe at an angle of someone's foot, and that would have been enough for a finding of infringement. And generally the UK courts, when a finding of infringement has been made, they're very much, you're getting a general injunction. It's up to the defendant to police it, right? We're not going to say you can do this and that. We're going to say you infringe the trademark, you won't infringe it again. You have to decide whether your conduct falls in and out of it. I wonder how a defendant might approach that. Might they say, well, there should only be an injunction in respect of this post-sale scenario, but then how on earth does a defendant police that? Because those post-sale scenarios arise through third parties, not in their control, using the goods. So that's an interesting line of thought there, and whether it would be fair to a defendant to have a general injunction saying any type of use of this mark assuming it infringes. I mean, I suppose maybe what a defendant might say is, well, there's a general injunction, but it was only found in the post-sale environment, and therefore our sale environment's fine. But I'm not sure how far that gets you, because once them goods are sold, they might fall into the post-sale.
Yeah.
Anyway, that's probably just a bit of an esoteric point. But I think as well, Stephen, obviously from your perspective now, and I mean, I've read a few IPO decisions, and they do sometimes consider how things might appear on the clothing and stuff, but it was always maybe felt that it wasn't really, because it was such a paper-based exercise. But I think now it's front and centre when you're doing trademark oppositions or clearance searches. You're going to have to be considering, well, what goods is the mark applied for, or what goods are we trying to clear this mark for? What other marks are there? How might what might be a realistic representative scenario where likelihood of confusion might arise?
Yeah, well, traditionally we've been very much focused on and encouraged to focus on, like I said earlier, the side-by-side analysis, but also the point of, we've always been looking at things from the point of sale. Now I think obviously we're going to be looking at things post-sale confusion, but I'm wondering whether or not this decision actually opens the door to initial interest confusion as well, which was raised many years ago, I think in 2010, and then was shut down by Interfloor. But from your perspective, do you think it opens the door for that?
Well, I think Interflora never got rid of initially. I think it's a misreading of the judgment in Interflora. Because what Interflora was, well, for two reasons. Firstly, advertising is a specifically prohibited act. But the Interflora decision wasn't about initial interest confusion, really. It was it was very specifically about keyword advertising.
Yeah.
And so it wasn't a general thing about initial interest confusion. It was really about when someone bids on a keyword and the resulting advertisement. That's what that case was about. And that was one thing we, I think when Dream Pairs got permission to appeal, one thing that they said was, well, you've got this discrepancy now between the court saying you can't have initial interest confusion, but you can have post-sale. And we were like, well, no, that isn't what Interflora says. However, I don't think it matters now. I think it's very clear that whether initial interest confusion was or wasn't on the cards, it certainly is now.
Yeah. And what would you say is the damage? Because obviously initial interest, the consumer or potential consumer was confused, but then that was rectified before the purchase. So what would you say the damage there actually is?
Well, I think on the same basis that, I think it's two. I mean, the trademarks have different functions, one of which is the advertising, investment functions, all the rest of it. But I think on the same basis as post-sale, the damage to the origin function is complete as soon as there's confusion.
Yeah.
So if you see an advertisement, you think, that's so-and-so's goods, but you're confused, that's the damage at that point.
Yeah.
You can't then undo the damage and say, but when they went to buy the goods, they realised. And so I think it's I think from a registry perspective, Stephen, it's going to make, do you think it'll make things more expensive? Do you think it'll make more, probably an infringement as well. People are going to have to there's going to be a lot more thought into maybe pleadings. Not that people don't put a lot of thought into now, but you're going to have to do maybe additional work on pleadings, additional work on evidence. Some of these realistic and representative scenarios you might have examples of. Some of them you might have to.
It might even increase the amount of marks you oppose, because if you do the side-by-side analysis, you say it's a clothing brand or a logo, and the marks are kind of similar, kind of not, or it's borderline, but then you bring in this other argument of post-sale confusion, that would encourage me and probably encourage others to see an opposition through or see an invalidation through.
Yeah. And
maybe even use the registry tribunal as a bit of a test before moving on to infringement as well.
Yeah.
But yeah, I think we're going to see an increase in both an increase in these arguments being run. I think we're going to see post-sale confusion, point of sale confusion. I think we're going to see initial interest coming back as well. And I think the volume of cases is probably going to shoot up. Like I said earlier, trademark searching is going to become harder. It's a really good decision for brand owners, current brand owners, but it's going to be very hard, very tricky for new entrants into the market as well.
Well, I think that's a good point, because I think this is, on one side of the coin, a very good decision for brand owners, particularly brand owners who are established, who've spent a lot of time and investment in building their brand up. And I think that is arguably a good thing. Where it might be less is, people can still be brand owners without owning a registered trademark, or because they don't need a registered trademark to sell under a brand. Or people who want to be brand owners, who are doing the right things by trying to do clearance search and apply for a mark. And arguably, in some cases, that might be more difficult for them, or it might be there's going to have to be a lot more, there might be more uncertainty as to whether bringing a brand to market is going to be clear and all the rest of it. So one might say, actually, this decision, a bit like Thatcher's, I think, well, my view, I mean, there's people with different views on Thatcher's, but it's very pro-brand owner, potentially not pro-competition. Similarly, this one, in some ways, might be thought pro-brand owner and maybe not pro-competition. Now, if you, let's just say, Thatcher's had, ignore the 10-3 case, they brought the claim against Aldi, essentially, as I always say, lemons for lemon cider, and it would have failed on section 10.2, but it might now succeed, not because at the point of sale, but about what might happen at home. And again, it's that competition. IP rights and competition naturally clash, okay? Just over their principles. Free trade and IP rights, they don't go well together. It's found in the balance. But obviously you can't have too much of one or too much of the other. Because, if it was all about free trade with no IP rights, then people just wouldn't create things or spend time and money. Similarly, if it was too if things were too sort of weighted towards brand protection, then that can stifle competition, increase prices. So it's an interesting debate, and it obviously wasn't one that the Supreme Court needed to get into.
I was just going to say, on that question as well about what we're going to see more of, although the Supreme Court didn't deal with it in this particular case, I think we are going to also see, in addition to the post-sale sort of context and a trademark infringement perspective, we're also probably going to see a post-sale misrepresentation for passing off. And I think that was mentioned in the Host case, as that post-sale should be considered.
Yeah, I mean, that's an interesting case, isn't it? I mean, that was, I think, David Stone. And from memory, I don't, either the defendant wasn't represented or didn't turn up. And there's a case in New Zealand which says that, I think in a passing off context, post-sale should apply. I think there's some debate as to whether it should apply in passing off, because it's different from registered trademarks. What you're looking at is a misrepresentation. But arguably people might say, well, that misrepresentation could be an ongoing misrepresentation. So,
well, it's essentially deceit or deception, and that deceit, deception, it doesn't necessarily have to take place at the point of purchase. It could, going back to your example earlier on, could take place in the home. Yeah,
so that'll be interesting whether people now, because I think after that David Stone's decision, I'm not sure whether it's really being pushed or considered further, but it wouldn't surprise me to see this arising.
I think so.
Right, so we've probably got about 20 minutes left. We'll quickly deal with the appellate stuff, and then
I'll just also say, if anybody's got any questions, also put them into the question answer box. And we'll deal with them.
We'll do 5-10 minutes more, then we'll have some questions, I think.
Yeah.
So the appellate one for me is quite interesting, and I've been I'm still struggling to get my head around this, because I think it's plain that if Dream Pairs had appealed purely on the basis that the court appeal shouldn't have interfered, I suspect the Supreme Court wouldn't have taken the case, because the Supreme Court is meant to be for points of general public importance. And they would say, well, that's a decision, the result of the decision, which the Court of Appeal adjudicated on and Mr. Justice Miles is between the parties. And if you look at it, it was interesting that the Thatcher's decision didn't get permission to appeal because arguably the legal points in that are of general public importance. And it's difficult to see the difference between the Court of Appeal interfering in Thatcher's and the Court of Appeal interfering in Iconix if the Supreme Court are correct and that Mr. Justice Miles, he considered everything and it was his view on it. And I think, Melissa Clark at first instance in Thatcher's, yes, I think there was bits, she might have got bits of passing off mixed up with trademarks, etc. But ultimately, it wouldn't have impacted her decision. It was bits of terminology. She just didn't think there was a clash between these brands, okay? So for me, it's interesting that should the Supreme Court, in the Supreme Court saying Iconix, the reason we give permission was these 2 points of law, but they upheld the appeal on the basis that the judge should have interfered. I still have, some people have said to me, well, no, it's the points of law with a hook which got the Supreme Court involved, but then that gives them jurisdiction to review the appeal itself. Yeah. But my point is, well, if they wouldn't have given permission to appeal on the basis the appeal shouldn't have overturned, how can that, if they then dismiss the points of law they got given permission, how can that be a viable basis to then, particularly when I think you've got, Mr. Justice Miles, obviously Lord Justice Miles now, obviously super smart, he's gone to the Court of Appeal, but he's not an IP lawyer. Whereas, Richard Arnold and Colin Burst are IP lawyers. And, I think to the day I die, I'll think that looks like an umbrella boot. And I know a lot of people feel like that, not people involved in the case. But I also know people who think Mr. Justice Miles made the right decision. But that's the beauty of what the Supreme Court says. They say that, look, in a light of confusion case, judicial or people who are with well-trained minds in IP can have different views. And I think what it was essentially a reiteration of the appellate principle of saying that the trial is it's meant as, I think it's in the Fage case, isn't it, where Lewison says it's the first and last night of the show. Yeah. And unless you can say the judge has there'll be some cases where it is just rationally insupportable, 2 + 2 = 6 or something. And it's like, you went through all the stages correctly and then just the answer's obviously wrong. But I think this is and it was a bit of a, I don't know, maybe a judicial slapdown at the Court of Appeal. And I think in paragraph 114 there, their wording was sort of saying, well, the court, essentially what the Court of Appeal thought was, because we think they're similar, the only reason, Judge, you must disagree is that you've got wrong. Mm-hmm. So I think that, I can see why the Court of Appeal, the Supreme Court adopted that approach. And I think it's going to be, when you're looking at multifactorial assessments, unless you can say the judge went materially wrong, it's not enough to say we had a different view. And actually, you saw that at the Court of Appeal in Lidl Tesco. It was so clear that the Court of Appeal thought this decision, we don't agree with this, and they say so in terms, but they uphold it. But it's then difficult to see why Thatcher's was overturned. But anyway, that's just an interesting, and I think people will say, are we going to see less appeals? Is the Court of Appeal going to be more restrained? I think you like appeals. You're good at appeals. I think we're going to see less of them because I think the Supreme Court was a bit of a slapdown for the Court of Appeal, and I think they're going to. I think the Court of Appeal are going to be, I think initially, at least on permission to appeal applications, probably scrutinise them a lot closer, particularly see, look, is this really just a multifactorial decision, which even if we think, wow, well, that's a bit, the judge could have had that view. But I don't think the way it won't impact appeals, obviously, is where there's a point of law where we said the judge went wrong or something like that. So I think it might have a bit of an effect. Initially, but we'll have to see, actually. Because
the Court of Appeal for a while, it started becoming a bit of a rehearing. didn't it?
Yeah, and I think people were saying that Court Appeal maybe giving permission to appeal too freely, or maybe giving permission to appeal but then dismissing the appeals in really short order. And basically saying, well, why not, if it was so clear you had that view, why did you even give permission to appeal?
Yeah.
So maybe we'll get less permission to appeal applications through, but I don't think it will impact on the ability to seek permission to appeal where there's an important point of law, maybe where the judge has gone wrong in the law, materially wrong. I mean, arguably, what you may say in some cases, well, for example, in the Morley's case, one of the grounds of appeal there was that the judge had said approach things from the drunk average consumer, which we got permission to appeal on. But Lord Justice Arnold said, well, that is obviously wrong. You can't have a drunk average consumer. But there's no reason to think if she had the correct consumer, she would have found differently. Mm-hmm. And again, that's sort of, I struggle to see how that applies with Thatcher's as well. Yeah. But it's all interesting for you being an IP lawyer. So, So we've probably got 5-10 minutes of questions. I hope I haven't bored everyone senselessly, you talking, but if everyone's asleep, did we get any questions?
Yeah, we've got some questions. I'll start with you, Stephen. Speaking of low-cost supermarkets, does this highlight the importance of registering product packaging as the overall impression is created by the packaging rather than the trademark?
Absolutely. And this has been a shift in practice in recent times. Obviously, brand owners and trademark lawyers have traditionally been focused on word marks, they've been focused on logos, but I think now, bear in mind, a number of recent decisions registering the look and feel of the packaging itself will add another weapon to your armoury and will probably assist in an infringement case as well. So absolutely, anybody with distinctive packaging should be looking at getting that protected.
And do you think this will apply to passing off going forward?
Yeah, well, I mean, we touched on that. I mean, there's one judgment in this jurisdiction from David Stone in I can't remember the name of the case. Yeah. And as I say, with the caveat that the defendant in that case either didn't turn up or wasn't legally represented, and David Stone applied a judgment from New Zealand, which says, I think it was New Zealand, saying that you could have post-sale considerations in passing off. I think people will certainly try and run it more, but I think arguably, whether it should apply and pass it off is potentially a question for the Supreme Court ultimately.
Maybe we'll start off in the tribunal, then you get an automatic right of appeal to the High Court. Maybe, like you say, it'll make it.
Yeah, exactly.
If the origin is clear at the point of sale, it's important to consider the reasons for the purchase. Has the product been purchased because it looks like a similar brand?
Well, yes. I mean, that's ultimately the question, isn't it? If there's confusion at point of sale, well, there's confusion at point of sale. The real issue is where, because of the context of the point of sale, there would be no confusion. And, that was obviously a position in Arsenal and Reed, where Mr. Reed was selling, effectively, counterfeit Arsenal stuff. But I think he had a big sign, maybe not saying this, but sort of saying, these are not authorised, you know what I mean? So anyone purchasing that knew it wasn't Arsenal goods. The origin function wasn't damaged. However, what the court said was, but if it could be damaged post-sale. So, for example, I bought that scarf for Stephen, say Stephen's a massive Arsenal fan, and I give it to him for Christmas, and he thinks, oh, that's legitimate from the club.
And starts falling apart or whatever.
But obviously there'll be some cases quite a lot of cases where the point of sale is also infringing.
And question for Stephen, how will this impact on trademark registration watch services? Will they need to consider post-sale confusion?
Absolutely, it's a really good point. I think all the comments that I made regarding clearance searching equally apply to the watching notices as well. So, whenever watching notice comes in, it's highlighting a third party potentially conflicting mark. Of course, you have to look at the side-by-side analysis, you look at the goods and services, so on and so forth. But then you've also got to consider, how the marks, the practical use of that mark in the wild, the post-sale and at the point of sale, and also now potential initial interest as well. So there's a lot more things to consider. Trademark searching, trademark watching has just got more complicated. On that, actually, there's a lot of AI companies that are trying to sort of, work in this particular field as well. I think there's more nuances, and they're going to struggle as well.
So maybe we've saved lawyers for a few years, yes.
I think so.
We're not all going to be
we're not going to be
on the scrap heap just yet.
Yeah.
This seems to have reduced the impetus of infringement claims, perhaps. In other words, traders might find it sufficient to oppose under relative refusals, what with the expansion to post-sale confusion.
I think it will increase if I've got a potential conflict. If I want to oppose somebody or invalidate or whatever, and like I said earlier, and I think it's borderline, and I start factoring in this post-sale stuff, and that increases the similarity. That's going to increase the chances that I win that case.
Well, and as well, the other thing to consider as well is, the registry stuff doesn't prevent use.
No.
So, someone applies for a mark and you win the opposition, that's irrelevant to whether they can actually sell the things on the market. And in fact, they never needed to have applied for a mark. They could have just sold. But yeah, it's an interesting point. People may well, because I think historically people did sort of, they did test the waters on an opposition first because it's lower cost, and now it's going to be able to bring them things in. It might be a way of getting a tribunal to make a finding to then say to them, look, realistically, the IPO was able to consider all these things. They said realistic and representative. An infringement action, the same result's going to happen. Yeah. So that is a really good question. It may well mean people, because there's really no difference now between registry and infringement, people might, if they're cost conscious, say, well, let's run these arguments in the registry and see what reception they get from a specialist tribunal.
Absolutely. And I think the flip side of that, though, as well, is, historically, you would get a decision before the tribunal in a very quick time frame. With the delays now before the tribunal, you're not getting decisions. You're not getting heard for 12 to 18 months, and the decision even longer afterwards. Brandsmiths might want to actually just get something dealt with quickly and maybe not use the tribunal as the test case and just go straight for it.
Yeah. Obviously, it comes with a higher cost risk, but yeah, it's a good point. I think the IPL do need to somehow sort that delay out.
Yeah.
A few more. Could there be instances where post-sale confusion can damage a trademark owner's chance of a successful opposition? Currently, it's very much judged as on paper. Is post-sale confusion likely to be considered in IPR oppositions after this judgment?
I think dealing with the first sort of aspect of that question, I don't think it's going to reduce the chances, because it's a bit like what you said earlier. This post-sale confusion can only be an additional weapon in the armory of the brand owner. It can't be used against the brand owner. So say there is sort of a lower risk of confusion in the post-sale environment, that does not go against the side-by-side analysis. So
I think one thing to add as well, which maybe didn't cover it, the Supreme Court essentially endorsed the principle from Picasso, which is that when you're considering the level of attention of consumers, you can't say there's a lower level of attention in the post-sale environment than there would be a point of sale. So in the case of someone buying a car, they're going to have a very high level of attention. And you may say, well, in the post-sale environment, there's certain scenarios you see the car and you're paying less attention. I think the Supreme Court said, they didn't say that was an incorrect principle. In fact, they said it was obviously a practical one, because otherwise you're going to have to consider, for every post-sale scenario, you're going to have to consider what the level of attention is.
Yeah. I think we've had this debate yesterday. There's an ongoing dispute at the minute between Ineos and the Ineos Grenadier and the Land Rover Defender, and it's a shape mark. I personally think that post-sale confusion now could assist a Jaguar Land Rover, but that's another thing on the impact on brand owners and trademark lawyers of this case. I think a lot of people will be reviewing current cases, current strategies, and making sure that everything's tip top and light of this decision.
Yeah. One or two more, do you think?
I think we've got 3 more.
Okay, that's fine.
So do you think real-world infringement in tribunal proceedings results in A, some different decisions to be what courts in an infringement case would do, i.e. be less favourable than side by side, and B, open up res judicata arguments?
Well, I think on the first one, my view is, well,
It should be aligned.
well, in theory there should be, but then this is the whole point about what the Supreme Court says, that in this multifactorial question, you can have really well-trained judicial minds who come to different conclusions. Yeah. I think the fact is both are now going to be considering more or less the same thing. In terms of res judicata, it's an interesting one, isn't it? Because in the registry, there's generally no res judicata from opposition, but it can be from invalidity. Yeah. I know there's a bit of gloss on that potentially, and whether it could be abused. But I think the general principle now would be, well, you could have a go in opposition, and that wouldn't really impact the prospect on infringement in the sense of being res judicata. But of course, where it always impacts is to say, well, look, judge, particularly if you have a non-IP judge in the High Court. Look at this hearing officer, really experienced, who went through all the law, considered everything, does trademarks day to day. They thought this, so they thought that.
Yeah.
Yeah.
I think, in addition to that, despite what we say, matters before the register, before the tribunal are still looking purely on the register, whereas in court they're looking at things in the marketplace. So whilst before the register we'll consider stuff in the market, and we should consider post-sale confusion, etc. It still is a registry dispute.
Yeah, exactly.
It has nothing to do with use of markets for that reason. For that reason,
I mean, it's got relevance use in market to the extent use in market could impact. But you're not actually, because one thing you often see is people say, well, I've applied for this mark. No, someone's opposing my mark, but they don't sell these goods. Yeah. But okay, next one's.
How do you feel post-sale confusion will affect the approach taken when considering the level of attention of the relevant consumer of the goods and services as part of the LOC analysis?
Well, I think I just covered that actually, which I appreciate was probably after the question came in, but the point is that you have to take essentially the highest level of attention, really. So what you can't say in the post sale is, well, the level of attention would be higher at sale, but it might be lower in post sale because you're a fleet and you have to assume they're the same level of attention. I can't really think of a scenario where you could say there's going to be a higher level of attention post sale than there would be at sale. Yeah. Because obviously at sale is when people are parting with their money, and that's if there's going to be a point where they're got their attention higher, it's when they're buying something.
Yeah, I don't think that scenario would exist.
And I reread the Supreme Court judgment this morning. It's sad. I've read it that many times and talked about it that I'm starting to get wholesale confusion as to what's right or wrong in it. But I'm pretty certain that the Supreme Court, they don't say the Picasso principle is wrong, which is that you can't have a differing level of attention in post sale. So the long short is they'll have to consider it from the same level of attention as they would at the point of sale.
And lovely last one for you, Andy. What advice would you give to junior lawyers hoping to one day work on a Supreme Court case?
Oh God, that's a good question actually. I think
lost for words.
I'm lost for words actually. Read the law, make sure you know the law better than everyone. Read it on Christmas Day, read it on holiday like I do, because I'm a bit strange. I think you need, I think ultimately clients have to back your view on something. And I think that comes to when you're advising clients, you have to be, you can't sit on the fence. You can't caveat your advice. Clients want you to tell them what you think's right or wrong. And I think giving advice that way, I think actually breeds trust in clients, even if actually the end result isn't that. I think clients appreciate a very firm and uncaveated view. But I think it also takes the right combination of client, case, because, a lot of clients maybe don't want to go to the Supreme Court but actually sometimes it's not their choice, because in both, in the cases I've done there, the Amazon one, the Armoured one, Iconix one, the appeal to the Supreme Court was actually from the other side, if you like. And to be fair, we were claimants in all three, and actually you bring the case, and if defendant, you can't really complain. But I think, I think all these cases take a combination of a lot of things to come together: the right client, the right case, and interesting legal points. But I think certainly in the last couple of years, we've had, particularly from trademark lawyers' perspective, we've had some phenomenally interesting decisions. And not just ones we've been involved in, lots of interesting, it's been, Skykick, all the rest of it. We've had a really interesting sort of couple of years as IP lawyers.
Yeah, and I think it's very important for the industry as a whole to push cases like this. And
I think so.
Get points clarified.
Yeah, thanks everyone for joining. Just one final thing I've been asked to mention. Because in the IP world, we're generally all very friendly and nice to each other. I did a podcast the other day with you and Gris from Bird and Bird, where we essentially had a discussion about the case as well. That is going out on Managing IP, I think, tomorrow, and I think it's free to listen to. So, if you want more of this discussion, tune in. Thanks, everyone.
Thank you very much.